Welcome to INN's Student. INN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Shreyas Vijay Sonawane. He is going to speak on Auditors under the Companies Act 2013. He is from Subhash Desai College of Law. So without wasting further time, I would request him to commence with the lecture. Thank you.
Hello everyone, I Shreyas Sonawane from Subhash Desai College of Law going to present on a topic Auditors under Companies Act 2013. So who are the auditors? Auditors are the one who look after the finance of the company. So let's get in a brief about the auditors under Companies Act 2013. Auditors are the qualified chartered accountants appointed by a company to conduct an independent examination of the company's financial records, ensure compliance with statutory requirements, and report their findings to the shareholders. The key provisions are covered in section 139 to 148 of Companies Act 2013. So there are some key aspects of auditors under Companies Act 2013. So they are as follows: first, qualification; second, disqualification; third, appointment and tenure; fourth, rotation; fifth, rights and duties; sixth, prohibited services; and seventh, removal or resignation. So let's get into short brief about the same. So first is qualification. An individual must be a practicing chartered accountant. If a firm is appointed, the majority of its partners should be practicing chartered accountants. And if an individual is conducting an audit, then it should be a practicing chartered accountant. So only CA partners are authorized to act on and sign on behalf of the firm. Like they must sign they have the full authority to sign on behalf of the firm. Then second, disqualification. Apart from CA, nobody can sign on behalf of the firm, as we can say nobody can sign on behalf of them. So there are certain individuals or entities that cannot cannot be an auditors to ensure independence, including a body corporate, then a company officer, etc. Then third, appointment and tenure. So for appointment and tenure, there are two types of auditors. First is first auditor and second is subsequent auditor. First auditor, for the non-government company, the board of directors appoint the first auditor within 30 days of registration. If it fails, then the members do so within 90 days at EGM. EGM is the extraordinary general meeting. For government organization, the comptroller and the auditor general makes the appointment within 60 days of registration. Whereas then second is subsequent auditors. They are appointed at the first subsequent auditors. They are appointed at the first general meeting, and they are holding the office till the sixth general meeting. Like it's a 5-year complete term. And they are subject to ratification of every AGM. Like ratification means the changes that should be made in the finances of the firm. Then fourth is rotation. So it's mandatory for the listed company and the other prescribed classes of companies. So there some of the prescribed classes are there, and the listed companies. Then an individual auditor can serve for only 1 5-year term, whereas a audit firm can serve for 2 consecutive 5-year term. So in that, like we say that if there is an individual auditor, then he can serve for 5-year term, and if he is from the audit firm, then he can serve for 2 consecutive 5 years, that is 10 years term. And a 5-year cooling off period is been provided if he is again going to join the same firm. Like he can go and make the audit in some other company, and then again come to the same company. Then fifth is rights and duties. Auditors have the right to access all the all the accounts, vouchers, and information from the company officer. And the primary duty include auditing the financial statements, complying with the compliance and for the shareholders and the public. Then sixth is prohibited services. To maintain independence, auditors are restricted from providing certain non-audit services directly or indirectly to the company or its subsidiaries, such as internal audit service, investment auditor, and management service. 7. Removal or resignation. An auditor can be removed before the expiry of their term, like for the 5-year term they are appointed, but if they are not performing well, then they can be removed below 5 years as well by a special resolution of the company, and with a prior approval of the central government, an auditor can resign, and it must file a statement in the prescribed form with the company and the registrar of the companies within 30 days. Means they get a time period of 30 days if they want to resign. So these are the key provisions that key provisions for the auditors under Companies Act 2013. Whereas so let's conclude the same. Like these regulations, like all the regulations and the key provisions for the auditors I had mentioned, they aim to ensure transparency, accountability, and integrity of a company's interest of its shareholder and public. So companies are required to file appointment notice in form of ADT 1 with the registrar of companies within 15 days of the meeting where the auditor was appointed. So like if they want to appoint a auditor, then they have to go through these clauses. Thank you.
Shreyas, thank you very much. It was a nice, crisp and a perfect representation as to what are the auditors, what are their authorities, what they are supposed to do, what they are not supposed to do. So it was a nice overview of auditors. A small token from Hammurabi to you.
Thank you.